as well as I annexed one
What is-
notification, one circular that was specifically stated that was overlooked, and I also, my lord, unable to place
So
before
have
your
you
lordship
filed a
review
review
application. My lord, any date for that reason the petitioner is not joined before the authority concerned. My lord, only one line correction because the notification specifically stated who are employed
your
after.
Wait for your turn. It is already there.
My lord, 289 of your lordship's list, my lord, that is.
What is the review you want?
Review, my lord, only date of implementation of the order regarding based upon the circular specification.
Transferred of which year?
My lord, this is transfer of 2023, and the circular
What
is
did we
2000.
direct?
My lord, that is from the date of publication of the circular, but in the circular there is a specification who are appointed on and from 2011. My lord, all the. I'm grateful. I'll do it in notice I am mentioning.
My lord, may I make one prayer? My lord, item number 3, I was engaged by the LRS, my lord, state responding.
Item 3.
3, but my other side is here.
I'm for the petition.
What are you mentioning?
My lord, I have not received the copy. My lord,
So please wait. Let it be.
my
My lord, with regard to item 70, my lord, I have
It is mentioned at the time of call.
my lord,
Yes.
70, my lord. I mentioned 70 of the combined list.
70
70, yes.
is for what?
My lord, for upgradation, my lord.
What is the
My lord, urgency is, my lord, data entry operators. My lord, already, my lord, we have given them their salary and everything. They are claiming arrears. Mr. Probal Mukherjee is for the other side. I have already, my lord, indicated his junior, Mr. Rajat Dotto. He also wants
You are
them.
Union of India?
I'm Union for India.
Wait for your turn.
My lord, it is pending since long. This is the third time I'm mentioning your lord.
All the list.
My lord, non-payment of gratuity, my lord. Non-payment of gratuity.
Where you are, which matter? Is it in the list?
No, not in the list. I'm mentioning.
You are not hearing.
It is hearing, my lord.
Which year?
Year up to 23.
Is it in the list? It is not in the list.
Not in the list, my lord.
Please sleep, let us see. Are you mentioning upon notice?
Yes, notice is there.
All right.
Thank you.
Seven WPF 4630 আমি অসীম কুমার অধিকারী এক্স সার্ভিসম্যান। আমার একটা কেস চলছে স্যার, 31 জুলাই আমি রিটায়ার হয়ে যাচ্ছি। কেসটার এখনো কোনো শুনানি,
কোন ম্যাটার?
পেমেন্টের ব্যাপার।
ম্যাটারটা কত নম্বর লিস্টে আছে?
4630।
হ্যাঁ
4630 স্যার, 15 তারিখে ডেট ছিল।
কি বলছো?
আইটেম
15
নম্বর তো
তারিখে?
বলতে হবে। 4630 15 তারিখে ডেট ছিল, আসতে পারে।
15ই
15th জুলাই ডেট ছিল স্যার, শামীম স্যার ছিলেন, অ্যাটেন্ড করতে পারে।
ওই অর্ডারটা কোথায়? এর কাছে অ্যাসাইন্ড হয়েছে।
এখানেই আছে স্যার, 11 নম্বর।
এটা তো সিঙ্গেল বেঞ্চের মামলা।
না স্যার, ডবল 11 নম্বর কোর্টে।
হ্যাঁ পাস হয়েছে সেটা কোথায়? কপিটা কোথায় অর্ডারের, যেটাতে আমরা বলেছি 15 তারিখ আসার জন্য? আপনার কোনো অ্যাডভোকেট আছে?
অ্যাডভোকেট শামীম স্যার।
হ্যাঁ
অ্যাডভোকেট শামীম স্যার।
ও, উনি সাহেব বিজি আছেন বোধহয়। আপনি চলে এসছেন। কি করেন আপনি?
আমি পুলিশে।
আপনার অ্যাডভোকেট আছে কিনা?
আচ্ছা,
তা আপনি এসছেন কেন একা? কোথায় আপনার অ্যাডভোকেট?
My lord, I'm appearing for
আপনার অ্যাডভোকেটকে এক্ষুনি ডেকে নিয়ে আসুন তো।
আরেকটা
কে
petition,
শামীম?
sir.
কে অ্যাডভোকেট? শামীম আহমেদকে এক্ষুনি ডাকুন, বলুন কোর্ট ডেকেছে। ইয়েস ম্যাডাম, ইউ ডোন্ট ট্রিট
My lord, I am appearing for the petitioner. Your lordship recollects, your lordship direct me to serve personally to the advocate who is appearing, Mr. Chirodip Sinha. My lord, that matter where as an officer of the court, I place the judgment of Justice Tandon, which goes against similar footing, my lord, though there is some merit, but anyway, my lord.
You are there.
My lord, Mr. Sinha informed me that Mr. Sinha has entire documents and copy of the petition has been sent to his client.
Yes, wait. Yes, Mr. Shamim Ahmed. You accept Vokalatnama and push.
I shall be like, retiring from the plea. That's the only option I
You to return.
that is the only option.
So he has named you that my advocate is busy in another court.
But I may be busy, but I cannot mention every day. Like, I have mentioned your lordship, that your lordship fix a date.
Lordship,
You are allowed on fix on next week.
So
I
your
cannot.
junior So your junior should have come and told us.
But, no, we have not instructed. I cannot instruct my client, but he has done so. But I should be retiring from that.
Already I handed
what
over
you
the
are
order to your lordship.
And Mr. Sinha told me that he sent the all documents and copy and letters, everything to his to the petitioner, but the petitioner applicant has not turned up to Mr. Sinha, and neither the Vokalatnama has been assigned to him till date, my lord. He has not contacted with Mr. Sinha.
My lord, earlier directly to the client also served, thrice served.
Yes, he is not responding.
Anyway, your lordship, my lord, there is an order, my lord. Being an officer of the court, I have already handed the order.
Where is your affidavit of service? You have
My lord, I have handed to your lordship, my lord, to Mr. Sinha, as your lordship directed. My lord, if your lordship kindly comes to the order of Justice Tandon, my lord, and sitting with Justice Vishwas, my lord, inner page 11, there is a relevant portion I may place, my lord. Sub rule 5 of rule 9. My lord, one thing, my lord, it is now becomes academic. Your lordship understands because there is a already judgment of the other bench. But the thing we want to, my lord, impress upon that bench, my lord, subject to correction from your lordship was,
So tell us the matter. What is this matter?
my lord, matter is, my lord, departmental inquiry, my lord, proceeding was just initiated under,
Just give us 2 minutes.
yes.
Do you have the pension rules with you, Mr. Mitra?
Yes, yes. I have, my lord.
Just now, it has been.
9 2A and 2B. Yes.
Yeah, it has been put. You
My
don't have.
anyway, please, your lordship may
It has
kindly
been
take.
quoted in the order.
Yes. নামটা
Railway Service Disciplinary Appeal Rules, Rule 9.
my lord. Rule 9, my lord, which just I'm giving the copies, both the copies to your lordship. My lord, we are happy.
This is Rule 9 of the pension rules.
Yes,
We are wanting Rule 9 of the disciplinary and appeal.
so that today, my lord, I'm
এখানে দেখো তো এই রেলওয়ে রুলস এর ইয়েটা আছে রেলওয়ে ডিসিপ্লিনারি এন্ড
বলতে কি ব্যাপার?
where is your RB 171 of 93?
Yes. 171, I'm grateful. My lord, your lordship kindly takes my supplementary affidavit. I have filed with all the OA application, circular, everything. My lord, your lordship kindly, I'm grateful, my lord. Comes to, my lord, page, my lord, 68 annexure P6. That is RB 171 of 1993.
Page 68.
Yes, annexure P6 of the supplementary affidavit.
No, it is not telling with us.
My lord, not telling. May I, my lord?
Page 68.
My lord, yes, annexure P6. That is the last page of the annexure, my lord, last page of the supplementary affidavit.
Supplementary evidence.
Yes, supplementary affidavit.
Last page.
Last page, my lord. 68. এটা কোনটা তিনটে রকম লিখেছিস কেন একটা 122 একটা 68 কি তাই মেনশন করছিস your lordship got, my lord, annexure P6. Yes. So, my lord, subject to correction, my lord, at the time of issuance of the first charge sheet, admittedly the person was in employ.
Was in employ.
So, my lord, our content, and that is only after submission of the charge sheet before the authorities, before passing any decision. My lord, so far 928 is concerned. 928. My lord, your lordship will find from there that authority lower the precedent. When the person was in service, he will consider that whether it will be presented to the president or not. Before that, this OA application was preferred. So one of my respectful submission before your lordship was that it is a premature. No order was passed, only charge sheet was filed. So the DA proceedings, he has the opportunity to continue and contest the DA opportunity, DA proceeding, disciplinary proceeding. Before that, my lord, he went to the learned honorable tribunal, and honorable tribunal exhausted. Now, so far, 2AB is concerned, it is meant for a person who has retired from the service. Then the question of sanction of president will come into operate. So this is a premature litigation where only after filing the charge sheet, which has been later on, my lord, withdrawn for technical reason, which is also covered by our rule, my lord, second charge sheet was filed. Now, admittedly, the second charge sheet is a continuation of the first charge sheet. So before that, he went to the tribunal. Now, the question was before your lordship to decide whether 92A will operate or 92B. Our respectful submission was that at that material point of time, 92A will operate because in paragraph 5 of my petition, my lord, I have indicated that in 16/3/2015, that person was very well in service. So he has all the opportunities to contest the DA proceeding. He has not availed the opportunity. And that was quashed on technical reason. And the second charge sheet was filed. Now, when the second charge sheet was filed, admittedly, the person was superannuated.
What did the coordinate bench say? Where is that order?
My lord, I have handed on the last occasion. Yes.
Yes, we got it.
Yes, your lordship kindly comes to the relevant part, that is from page 11 onwards. May I place, my lord?
Yeah, just.
Yes, sub-rule 5.
Page, Mr. Mitra. Page.
Yes. My lord, page 11, your lordship got, my lord? Page 11, the paragraph starts, sub-rule 5 of rule 9 of the said rules indicates when the departmental proceeding would be deemed to have been instituted. In other words, it defines the date of institution of the departmental proceeding. It is manifestly clear therefrom that the departmental proceeding shall be deemed to have been instituted on the day when the statement of charges were issued to the railway servant, or if the railway servant has been placed under suspension from an earlier date on such date. Therefore, the departmental proceeding shall be initiated on the date of issuance of the statement of charges upon the railway servant, or if he was put under suspension, then from the date of such suspension. If the rule has clarified and defined a particular situation, then wherever the situation is contemplated in the said rule, the same definition would be assigned, and no external aid for the purpose of interpretation is warranted. The moment the date of institution is included in the rule itself, then such institution would be deemed to have been made on the basis of such definition and cannot be interpreted in such manner which would frustrate the object and purpose of sublime incorporation thereof. It is no longer res integra that the statutory authority cannot do a thing not contemplated in the statutory document, nor should be permitted to travel beyond the circumference thereof. The rules have a statutory flavor and cannot be undermined, nor be permitted to be flouted at the behest of the authority. Mere making certain observations by cancelling the earlier statement of charges or the proceeding does not whittle down the rigor of Rule 9(2)(b) of the said rules. Now here I am pausing here for a moment, my lord, with greatest respect and utmost humility. Our contention was before that bench 9(2)(a), not 9(2)(b). We are harping on 9(2)(a). It is beyond cavil of doubt that the moment the entire proceeding is quashed and set aside and a fresh notice or the statement of charges or article of charges are issued, it would be regarded as a fresh proceeding, and doctrine of relation back has no manner of application in this regard. Something which perishes cannot be recorrected by taking sarcastious route, invoking the provision diametrically.
This was a employee under you at
Similar circumstances. I must be candid before your lordship.
Yes.
That person also, my lord, before retirement, 9(2)(a) proceeding was drawn up.
May I take your lordship's leave, my lord?
Similar circumstances. That an officer of court, my lord, I must indicate, my lord, whether order is in our favor or against that. And till now, my instruction is that railway has not preferred any SLP against this order. Till now. So this is the facts, my lord.
Oh, he was also he was in the same place. This person was in the same place as the other one. That you do not know.
No, that I can, my lord, ascertain. That I can ascertain.
The
But
present
my lord,
petition
so
has
far,
been referred,
yes.
challenging an order dated 15 July 2020, passed by the learned tribunal in the original application bracket in short bracket close comma being way 323 of 2020. By the said order, the learned tribunal first charge sheet dated 18 July 2019 issued against the petitioner. Observing inter alia that Mr. Mitro, learned advocate appearing for the present litigation has been by the Union of India and its functionaries. Mr. Mitro, learned advocate appearing for the petitioners submits that Rule 9 of the Railway Services bracketed pension rules, 1990 bracketed hearing after referred as the 1993 rules. Contemplate a situation where disciplinary proceeding may be instituted after the retirement as the article of charges after the stop. The article of charges issued on 25th বলেছো তো কি লিখেছো submits that 9 of the 93 rules contempt the situation where disciplinary proceeding may be instituted after the retirement of the stop. The tribunal, the learned tribunal, has erroneously interpreted and misconstrued the provisions contained in Rule 9 of the 1993 rules, and therefore the impugned order is liable to be used. Further argues first charge sheet in this case was also challenged earlier.
No.
He further argues that the cancellation of the first article of charges by an authority and issuance of a fresh article, cancellation of a charge sheet by an authority and issuance of a Fresh charge sheet pertaining to the same incident of misconduct can be regarded as a continuance of the proceeding. Such arguments, as urged, were glossed over by the tribunal, and no finding was returned on the same. Of such infirmity warrants interference of this court. For a affidavit of service filed by the petitioners be kept on record in spite of service, no one appears on behalf of the respondent. Mr. Mitro, however, in his usual fairness, submits an identical issue came up for consideration before a coordinate bench of this court, and the said petition preferred by Union of India and its functionaries was dismissed. We have heard Mr. Mitro, and considered the materials of record, including the said judgment dated 14th December 2020, as produced, the capital. We have heard Mr. Mitro and considered the materials of record, including the judgment of the coordinate. Records reveal that a charge sheet dated 2015 was issued to the petitioner prior to his superannuation. The said charge sheet was, however, cancelled / dropped without prejudice by the disciplinary order. Admitted, the fresh charge sheet issued to the petitioner was not under Rule 9 of the 1993 rules, but under Rule 9 of the Railway Services Disciplinary and Appeal rules. Stop. The learned tribunal observed inter alia that Rule 9 Disciplinary and Appeal Rules, 1968, herein after referred to as the 1968. The learned tribunal observed that line of the 1968 rules applies to a serving employee and as such, the same could not have been issued against the respondent subsequent to his retirement on. When did he retire, Mr. Mitro?
Yes, my lord.
Subsequent to his retirement. They are making clear endorsement of certain, clear incorporation of certain observations while cancelling the earlier charge sheet does not begin down the river of time of the 1993 rules. Stop. The moment the entire proceeding is quashed and set aside, moment the entire proceeding is quashed and set aside, and a fresh charge sheet is issued, it ought to be regarded as a fresh. It ought to be regarded as a fresh book. In the said conspectus, the learned tribunal arrived at a finding that that the, that the second charge sheet had been issued under a provision that would not apply to a pensioner. The learned tribunal, upon dealing with the issue, the issue involved in the present petition is identical to the issue considered by a coordinate bench of this court in the judgment dated 14 December 2020. In the said conspectus, we are not inclined to interfere with the order included in the present petition and the the writ petition being such and such is accordingly dismissed. There shall however be
This matter will appear on the
Okay. 13 December is under challenge.
yes.
13 December. It's going
মানে 14th of, as per my memo, মানে 14th of November, 14th of October 2015,
Which portion?
page 27.
Yes. Now, which portion applies to it? He was a
Page 28, your lordship kindly comes.
page 28.
28.
No,
2014 circular has been amended. 2014 circular has been amended.
where is that? Page 28.
Page 28. Pursuant to the directives of Honorable Supreme Court dated 31/10/2013 in WP such and such, instruction were issued by votes letter number such and such dated 10th of June 2014 for constitution of the placement committees for officers and staff working on zonal railways in various offices or work units. Some of the zonal railways have been expressing difficulties in implementing the above scheme and suggesting alternative ways to form the placement
Very
committees.
good. Kindly come to page 29,
My lord,
clause 2.
my lord.
Board has therefore decided there should be a placement committee to recommend transfer posting of all railway as per Honorable Supreme Court's order.
Yes.
Now, he belongs to clause 4 for
He-
officials or group.
He belongs to my lord, clause 4,
He belongs to group 4.
clause 4,
Sure.
2/4,
Group C.
group C.
So competent authority to accept is DRM,
Yes.
and the was the transfer order issued by the DRM?
Yes. My lord, kindly cease.
Transfer order is 2020.
ADRM is approving authority. ADRM is approving authority. As per order of the Supreme Court.
20th.
But
Both DRM as well as ADRM.
both.
Now, your transfer order of 20th July 2022.
Yes.
Where is that transfer order?
And
As per order page.
page,
Page num-
your lordship
Page
kindly comes
32.
page 32 first, 33 second. Last transfer order, 20th July 2022. Well, in my lord, date petition.
Within 1 year.
This was issued by whom? This was issued by the assistant
Assistant personnel officer.
Huh?
Assistant personnel officer.
He was not the DRM or ADRM.
Approving authority, my lord, DRM, ADRM, approving authority. Approving authority is, my lord, DRM or ADRM.
Yes. So show us that it was approved by the DRM or ADRM. This policy came in. অনেক আগে, অনেক পরে, 20/7/2022। সেটা হচ্ছে পেজ 33 তে। এই যে সিনিয়র ডি কম্পিটেন্ট অথরিটি, এখানে সিনিয়র ট্রান্সফার পলিসি page 33, Mr. Dalal.
My lord.
It's the transfer order.
Page 33. Page 33.
Please kindly 33 you have got. Kindly come to note 2.
No, 2 years, my lord.
This has recommendation of the placement committee duly constituted in term of posting policy 2018.
My lord.
Where is this posting policy of 20th August 2018? You are showing us page 22. That is of 2014.
2014, that is subsequently amended, circular has been amended in 2015.
Oh, acha.
That is 2015. That is in terms of 2015. He is relying on 2014. Subsequently, it has been amended in the year 2015.
এই লেটারটা হচ্ছে by which the dismissal duly constituted the complete terms in terms of 2008 letter.
সেই posting and policy. সেই পলিসিতে তো দেখাচ্ছে না।
না না সেই পলিসিটা আগে থেকে এটা চিঠিটা এটা চিঠি এটা by which the placement was completed in 2008.
But one of the senior DENs कुछ कर नहीं सकते आपके लिए। आपको ट्रांसफर पोस्ट ज्वाइन करना है।
But my lord, on justice,
आपको हम लोग सुने हैं।
on justice was taken, every matter to be heard, then decide what are the right or wrong. Because various type of humilities are adopted by the higher authority, not only humilities, defamatory matter. Otherwise, why remove me from the post of in charge within 1 year? What are the deficiency? If I am working about 22 years on that post, then
How many years you are working?
In charge, as in charge.
only 1 year, single year. Only 1
As
year.
in charge for approximately 1 year.
1 year. Whereas private respondent already work on about 6-7 years and he also removed me from the post of in charge for 5-6 months. Or there are any allegations?
The present repetition has been preferred. Challenging an order dated 13 December 2023, passed by the learned tribunal in the original application being OA. Enough to be cut. Bracket close, comma, being OA 1398 of 2020. What is this MA number and CP number?
MA number is miscellaneous application was there, and CP contempt petition was filed by there. Because of the fact 5th of August 2023, that was 2022, that was an order. Interim order, ex parte interim order was there. That has been violated. Your lordships kindly have a look. In this matter, in way. আচ্ছা এগুলো করতে পারবে দেখো কোথায় আছে
Initially, an interim order was passed.
Initially, interim order was passed.
Page.
Page resignation আছে আছে may I না দাঁড়াও না এখানে আছে তো
5th August.
5th of August 2020 2022.
220.
Lordships kindly have a look page 88.
We heard the matter last week. We are still asking you. We heard the matter last week. We cannot interfere with the order. So are you willing to go and join there? Then we can issue some protection in your favor.
My lord, Private respondent to be directed to leave the post.
Where is the interim order?
Well, page 88
Page
of the writ
88.
petition. Yes, my lord. Page 88 of the writ petition. Have you noticed got?
এখানে page 78 এ দেখো। এটা আরম্ভ হচ্ছে পেজ 77 10/6/2024 হাজারবার চেঞ্জ
Thereafter, well, interim order extended, well, page 90.
page
Up,
9 page
interim order
90
extended up to, well, 2 weeks.
then what happened?
Then there was no interim order. Matter was and
There was
direction
no-
direction affidavits was my lord, if you just kindly have a look, page 90.
Thereafter it was not extended,
It was not extended.
and for alleged violation of the order he filed a contempt.
Contempt application.
Then what happened in contempt? It is still pending.
Not still pending, my lord, dispose of contempt. If you just kindly have a look, my lord, order of the, my lord, tribunal, landlord tribunal.
Page
পেজটা অর্ডারটা লিস্টটা করা আছে নেই মানে কাইন্ডলি হ্যাভ এ লুক পেজ 30 36
36
36 আর 37
of
এটাই কি এটা yes of my writ petition
is
writ petition 36 of writ petition
36
36 37 and 38 MA is disposed of on last page one and any MA or last page of the order MA is disposed
that
of
is the
accordingly
order dispute.
order impugned, my lord, at page 34
Where you are reading?
page 34 last page one 34 35
Huh?
36 37 38 page 39 39 last page of the order
আসো past in MA past in way such and such বলেছো তো? and the connected applications being MA 742 of 2022 and CP 140 of 2023. MA was for what?
miscellaneous application
By the said order, the learned tribunal refused to interfere with the transferred order refused to interfere with the transfer order issued to the petitioner. The transfer order dated 20th July 2022, by which the petitioner was transferred, from the post of junior engineer bracketed capital T stop way W টা capital, bracket close, from the post of in charge, in dash charge, এই যে এখানটা আছে দেখে নেবে পাতাগুলো না দেখবে, post in charge SSE bracket permanent way
MA,
same station
MA was for vacating the entry order.
on your part at the same station. By refuse to interfere with the order of transfer dated such as Mr. Yadav learned advocate appearing, Mr. Yadav, the petitioner appearing in person submits that transfer order was issued by an incompetent authority Mr. Learned appearing in person submits by an incompetent authority, was issued by an incompetent authority and it said transfer order was also not placed before the placement committee for its requirement as for its recommendation stop. He further argues that the transferred order was an order of demotion, and by the same the petitioner had been penalized. So, if such argument as advanced before the learned tribunal were glossed over and no finding was returned on the same. Stop. Drawing our attention to pages 88 and 90 of the original application, Mr. Yadav further submits that initially an interim order was passed on a prima facie finding that the transfer order had been issued by an incompetent authority.
রেলওয়ে ডিভিশনের অফিসারের জন্য টিআরএম ছিল সেইটাকে চেঞ্জ করে হচ্ছে সার্ভিস ক্যাডার
Next paragraph. Interim order was passed. However, the said interim order was thereafter extended for a interim order was passed on 5th of August 2022, and the same was extended by an order dated 17th August 2022. Stop. As the respondents did not comply with the said interim orders, said interim order, comma, the petitioner was also constrained to file a contempt application being CP 130 of 140 of 2023, and prior thereto a vacating application was filed by the respondents being MA 742 of 2020. 742. Mr. Yadav contends that the impugned order of transfer was not in public interest, but was issued for collateral purpose with oblique motive and in colorable exercise of power. Stop. Such in the said order was also not in consonance with the transfer policy. Transfer policy was also not in consonance with the transfer policies. Totally, such arguments as advanced were যেটা আগে দিয়েছিল সেটা এখানে ঢুকে গেছিল. Per contra, Mr. Kumaresh Dalal, learned advocate appearing for the respondents, submits that the petitioner has been transferred from one post to another in the same station. In view thereof, no unsurmountable difficulty had been caused to the petitioner. In view thereof, in the same station,
In the same
and
pay
the
scale.
allegation,
Pay scale is also same. Pay scale is also same. Pay scale also same.
and was also placed in the same scale of pay.
Right.
In view thereof, no prejudice has been caused to the petitioner. He further argues that, drawing our attention to the transfer order, he argues that the same was issued
My lord, as
on
per,
the
as
on
per
the
26
recommendation
page,
of the placement committee, recommendation of the placement committee, and was also approved by the competent authority. In support of such contention, he has drawn our attention to the circular dated 21st September 2015 and the circular dated 10th June 2014.
2014.
As the petitioner is appearing in person, 10 June 2000, we have heard the petitioner in appearing in person and considered the materials on record. Stop. Consider the materials on record. The argument of Mr. Yadav that the order of transfer was in fact an order of demotion is not acceptable, since he has been transferred in this, he has been placed in the since his pay scale which he was enjoying had not been disturbed. Education also not education. There was not. Furthermore, such order of transfer furthermore, by the order of transfer, the petitioner had been sent to a post in the same station where he was earlier working. Perusing the stuff in which he was earlier working. It is also not a case. It is also not a case that the petitioner, that the transfer order was issued by an incompetent authority. Upon perusal of the records, the learned tribunal came to a finding that that the transfer order had been issued by the competent authority and in pursuance and in pursuance of the recommendation of the placement committee. Next paragraph. Stop. Transfer is an incident of service and if necessary in public interest and for efficiency in public administration. Stop. A government servant, a railway servant has no legal right to be posted at any particular post, and he has no authority to continue in the post indefinitely. It does not appear, it is also not a case that the transfer order had in any, by the order of transfer, the petitioner, it is also, stop. Applying such proposition of law to the facts of the case, we are not inclined to interfere with the order impugned in the present dispute petition, as the same does not suffer from any patent error of law. The writ petition being such and such is accordingly dismissed. So, এটা কত page 82. Page 82. Page 20. Yes, next.
I am for the petition.
Yes, what?
My lord, I am appearing on behalf of the respondent number, my lord, 1 and 2.
No, why were you?
My lord, I have received the copy. That's why.
You
Receipt.
Petitioners, before
Just
your
1
lordship,
minute, one.
my lord,
You are for the original applicant.
or applicants. They moved and they were the casual driver, my lord. They applied for regularization, my lord, and the tribunal passed an order to consider.
Where is that?
Within 15 days, my lord, page 53, my lord.
Page 53.
Page 53, my lord. They obtain the certified copy within, there is a direction to apply within 15 days, my lord. Made representation. And they made representation, my lord.
Beyond that,
There is some delay, my lord. Beyond that period, my lord. Passed the order on 30th June, my lord, and thereafter they applied on 5th September, my lord. And there is some delay, my lord, after obtaining the copy, and there is some communication
where is
delay, my
that
lord.
representation? Where
My lord,
is
my lord, my representation is, my lord,
Page 60, my lord.
page
60.
60, my lord. They made individual representations, my lord.
25th January
54, my lord.
25th January 23.
54, my lord. 54 onwards.
One was submitted on 5th September.
5th September, that is the
Then
representation.
what is this 20? Oh, that is the representation.
There
you
is a
sub-
54, page 54, my lord.
So that was not considered.
That was not considered, my lord.
So you
I
came for
filed a contempt application, my lord. And the contempt court considered that there is some delay after, on very technical ground, my lord, it was rejected. That is my only prayer, my lord. Let there be a direction to consider my representation.
Contempt daily. He will withdraw this writ petition. You consider and pass a
Fine.
result.
My lord, my lord. Let them consider.
The present writ petition has been preferred, challenging an order dated 30th November 2023, passed by the learned tribunal in a contempt application being double CP 18 of 2023, preferred alleging violation of an order dated 30th of June 2022. Passed in OA 204 of 2016. By the order impugned, the learned tribunal refused to by the order impugned, the learned tribunal observed that the contempt application was not tenable and accordingly the same was disposed of. On a ground that the representations were not submitted by the petitioners within the time as directed by the learned tribunal on 30th of June 2020. Upon hearing the learned advocates and considering the materials on record, we find we find no reason to interfere with the order impugned in the present writ petition, and the same is accordingly dismissed. However, as initially an innocuous order was passed towards consideration of the representation, we can record your submission.
Let it be court's order. Let it be court's order.
Then again, he will come.
Again, he has to come.
If we don't consider. Whether he will-
Consideration order, it may
Contempt
be
must be
considered, may
acknowledged.
not be, but let it be court's
No,
order.
he will come before us.
Component number 2, acknowledge the representation, my lord, and directed to the DM Purulia to consider, my lord, although they have not considered. Page 57, my lord. The state respondent acknowledged.
You should have filed an application for execution of the order. You did not file that.
Time has been, same order will pass, my lord, let them consider, my lord. Purpose will serve, my lord.
How can we pass a further order of consideration?
My representation is there, my lord, and they acknowledge. Page 57, my lord. State respondent acknowledge and directed to the DM to consider.
Page 57.
Page 57, my lord.
No, you made representation to
On
whom?
5th September,
5th September, it was forwarded to the DM.
my lord.
Earlier.
এটা 18-10-2022
60.
হ্যাঁ।
It is in respect of earlier. September is a
Representationটা তো
45.
না অর্ডারটা তো হয়েছে
I have talked to all the respondents.
লিখলে
However, as initially
না না
upon hearing the learned and considering the material, so we find no reason to interfere with the order in
we find no reason to interfere with the order. Since there had been no deliberate or willful violation of the order passed by the learned tribunal on the part of the respondents. However, the records reveal that 3 months, মানে 90 দিন। What was the reason for not submitting in time? You submitted it 3 months thereafter.
There is not 30th June, my lord, only June and July and August, my lord. That 2 months, my lord. Around
3 months. You were asked to file within 15 days.
15 days, my lord. Obtaining the copy, my lord. There is some delay, my lord.
Where have you stated?
I have stated, my lord, in page 11, my lord.
Page 11.
The ground, my lord. Page 8, my lord. Paragraph number 12, my lord. I have also stated, my lord.
since there had been no undeliberate and violation of the order passed by the learned tribunal on the part of the respondents.
The records do reveal that there was a delay in submitting the representations within the time specified by the tribe. The learned advocate appearing for the petitioner, however, submits that after obtaining the certified copy of the order, the representation was submitted. That is the joint representation.
No, that is separate representation. There is a direction to submit the separate representation, my lord, for the respective parties.
So where are those representations?
54 onwards, my lord.
The learned advocate appearing for the petitioner submits that after obtaining the certified copy of the order,
The
The
representation was submitted. And the same was forwarded to the respondent number
3.
3. Vide memo dated 18th October 2022, passed by the respondent number 2. Which they now Mr. Bandyopadhyay submits that the order passed in the original application was an innocuous one, and the petitioners are, and there was no willful delay on the part of the petitioners in submitting such representation, and accordingly prays for a direction, and accordingly the authorities condoning such delay, and accordingly the authorities may consider the same. Such prayer of Mr. Bandyopadhyay has, however, not been opposed by Ms. Nondi, learned advocate, has, however, not been opposed by Miss Nondi, learned advocate, appearing on behalf of, has not been vehemently opposed by Miss Nondi, learned advocate, appearing for the respondents. In view thereof, has not been in view thereof, the rest is also appearing along with you.
Serious matter.
Miss Nondi, you are for
1 and 2, he is for 3 and 4.
has not been vehemently opposed by Miss Nondi, learned advocate, appearing by Mr. Mukherjee, learned ATP, appearing for the record number 1 and 2 and
3 and 4. 3 and 4.
Mukherjee has not been opposed by me, senior Mr. Mukherjee and AGP, appearing for the respondent numbers 3 and 4, and by Miss Nondi, learned advocate, appearing for the respondent numbers 1 and 2. It is expected in view thereof. In view thereof, the respondent number who has been asked to consider
The 3, district magistrate.
DM Purvi.
3.
3.
In view thereof, the respondent number 3. Any
Yep.
opportunity of hearing was given?
None.
Eh?
No opportunity.
In view thereof, the respondent number 3 shall consider the individual representation submitted by the petitioners as annexed to this writ petition within a period of 8 weeks from the date of communication of this. Um, mm, from the date of communication of this order to all the respondents. No, respondent number 3 will consider.
Yeah.
Uh, 3 is the now, Mr. Mukherjee, the first one was forwarded on proper channel.
Yeah.
The other representations, I don't think it has been done.
No, but let him file a fresh representation that.
Fresh, we will within within a period of
8
weeks.
কি বললো?
A period of 8 weeks
8 weeks
from the date of completion of task.
Individual.
as annexed to this writ petition, within a period of 8 weeks from the date of communication of this order, along with a copy of the writ petition. The above observations and directions, the writ petition is disposed of where shall have. Yes, next.
No, my lord,
Petitioner respondent,
একটু নাম্বারটা দিন, you are for which one?
I am appearing in item 4 next month.
Oh, no, there is a
12
There is such.
which is your matter?
like 87, 88.
So that education matter?
No, no.
That postcard matter.
Postcard matter.
Acha, acha.
He
Not,
was making his submissions. We were
Mr. Dotto, come back on another day because let us go through the motions. একটা দিন বলে দাও না। First আচ্ছা, 1st August at 2 PM. You have finished your arguments. আমার requirement আছে
Mr. Dotto, 1st August. How long, how much time? You have finished.
He has finished, my lord. We were supposed to, my lord, Mr. Mujumdar was reading me. We were just, my lord, to conclude.
আচ্ছা, ঠিক আছে।
My lord, I has to come to
We will also forget. That is why we are keeping it immediately. 1st August 2 PM করে দিও। Yes, next. Item number 4.
I appear for the petition.
My lord, anytime next week, is it very difficult?
হবে না, সব ফিক্স করা আছে। We will finish it up that on that day. Yes.
2 PM.
My lord, all the respondents have been served. There is also an affidavit of service. My lord, may I just briefly say, because apparently it might look that it is not, I am not challenging the final order by the learned tribunal. So apparently it might have a look that there is nothing in the order. Why did I challenge it?
Yeah, then let us go through the order.
Lordship, then first kindly look at page 274A, first order, thereafter the order which is under challenge. Then
13, first
Page-
order is date.
9th of May, page 274A.
Yes, and the second order is 13th of June.
Right.
Both you are challenging.
I am challenging 13 June, but well, 13 June cannot be understood unless that
Alright,
is
then let-
read. Short order, 274A.
আচ্ছা, আচ্ছা। Who are the private respondents?
And all are served.
Some of the private, others have been served.
Well, there
Have
are,
you checked up?
well, there
check
are,
up করেছো?
all have been served, but the interim order, what I am seeking is that they would not be dislodged. I am only seeking protection for future.
আচ্ছা, ঠিক।
I don't want them to be setting aside. That's a final relief. I'm not asking that.
Yes, tell us what
Yes. My lord,
interim order, not
Correct.
to
My
fill
lord-
up two posts.
my lord, what I am seeking is, Lordship, may kindly straightway see page 173. 173. Or if I can, well, if I can just say, what I am seeking, my lord, first, my relief that I sought was that this 25 promotion was wrong. But that is the final, I cannot ask in an interim order. But I am seeking that in the meantime, that is November, whatever, if you want to hold any further promotion, which they are in the process, please follow the specific promotion rule where if there is one vacancy, they should ask for 5 persons. That's the zone of considerations. Lordship, may kindly have a look at page 173. That's a rule made under Article 309 by the state.
So when the matter has been fixed,
In November
November, your lordship.
and
11th of
November, and there are
November.
25 persons they have given promotions. There is absolute secretively neither advertisements, neither any vacancy knowing, and neither this 1:5 being followed. I say at least whatever has been done, that can be found whether right or wrong in the final hearing. But 173, Lordship may kindly have a look at this rule, clause 2. Well, may I place that? Notwithstanding anything contained in any rules or procedure regulating the recruitment to the any service or post under the state government, by promotion, normal zone of consideration in respect of promotion to such service or post shall consist of such of the employees eligible for promotion to such service or post according to the rules or procedure. এটা কি?
Relating to
regulating the recruitment thereto as occupy when arranged in descending order of the seniority thereafter. 5 times the number of vacancy or vacancies actually available for filling up promotions at the time of considerations. I say that this tribunal directed, Lordship may kindly have a look at page 159. In my original applications, along with some other applicants, that experience of MSc has to be considered for the purpose of promotion to senior lecturer. Kindly see page 159, the paragraph starting from in view. In view of our above findings, we do not find any illegality of irregularity or arbitrariness in preparations of the publication of the seniority list, whereby the private respondents have been placed above the applicants. It's a direct and we are the lateral induction. It is true that the applicants are not entitled to get any benefit in fixation of the seniority above the directly recruited clinical instructions during the period of 5 to 10 in terms of the seniority rules. But the experience of the applicants as nursing personnel in West Bengal Nursing Service before their lateral inductions into the cadre of clinical instructor may be taken into considerations for their further promotion to the post of senior lecturer in terms of such and such. In this 2013 rule. Now, Lordship may kindly have this, and this was not challenged. Now, I say that if you have to consider experience, how do you do that? If there is one vacancy, because of the 82 rules, you have to ask for 5 times more, 25%. Once you get the 25%, then you have to have a mechanism, and that mechanism is there in the rule itself. Lordship may kindly have a look that.
So what interim order you are seeking?
I am only seeking this. May I come to the order? Then I am seeking. Page 275. That's the orders. Kindly come to 275A.
So to ascertain that percentage, the lateral entry numbers have been sought to be disclosed by them.
They have never disclosed that.
That is what the tribunal asked.
What I'm asking is this.
You are through lateral entry.
I am from the lateral entry.
From
I got the MSc much before in comparison to most of the other candidates.
The previous order of 2013, which is that page?
That is at page 159. Operative part.
That's from 151, Your Lordship.
Correct. 2013 rule and experience. And Lordship,
you were nursing personnel in West Bengal Nursing Service.
Yes.
From that, you obtained lateral induction as clinical instructor.
Correct.
And the next promotional post is
senior lecturer.
Senior lecturer.
Yes. Now the rule says, forgetting the order of the learned trial, rule says that for these promotions, the direct recruitment method, whatever is prescription, that has to be followed. And in the direct recruitment method,
that was not followed also in 2019 when you came.
No, my lord, I am not on the seniority part, not on the gradation list part. I am saying when promotion is to be given, the promotion is to be given on the basis of first zone of consideration.
That you could have agitated in the first.
No, my lord, that is on the seniority list. That 1, 2, 3, 4, 5, 6, that will come. So that cannot be tinkered with. But assuming tomorrow there are 5 vacant posts to be filled up for senior lecturer, I say that because of this specific rule of 82, if you have to select 5, then you have to call 25. That's the rule. Out of 25, now you see who has got the experience or your own mechanisms. I don't say that I would interfere into that. Now, why this has to be done? For 2 reasons. Reason number 1 is the tribunal's own order that experience has to be taken into account. And reason number 2, which I have not yet shown, is Lordship may kindly have a look, the page 119. Their rule also says so.
So why did you approach the tribunal in 2017?
My lord, I approached the tribunal saying that the senior
we should be senior.
I should have been in higher in the position.
Than the existing clinical
who
instructor.
came directly. Because I have got the MSc much before with most of them.
So that prayer was negated.
That prayer was negated that no, the list is right. I say fine, list is right. But for the next promotion, MSc is a must, is the first criteria. And the tribunal said that experience has to be counted. And rule also says, if I can show the rule, I have not, kindly have a look at the rule.
No, that 1:5 you said that is for one promotional post. There must be
25
five-
persons have to be called.
How many promotional posts are vacant?
My lord, so far they have promoted 25 persons.
Hmm.
And these are absolutely in secret. There is no notifications, nobody knows. That's the reason I said, in the meantime, my lord, kindly protect in this sense. I have two interim prayer. One, 2 vacant posts may be kept vacant. 2, the promotion I have challenged, let them not be dislodged, let them continue. But if you want to go for further promotion, please follow the zone of consideration rule. Because if the zone of consideration rule is not followed, well, how I get suffering?
Your suffering will be redressed at the time of final year.
Well, it may not. Then I have to kindly see. Today I have
That is you are seeking
Well,
a
today-
final relief at the
Well,
interim stage.
well, today 25 persons I had to make them. Because I had to make 25 persons as parties.
Very good.
Oh,
Today, if you win, you will go above.
Well, this, may I say, well, kindly see the difficulty. All I'm saying is, well, kindly consider this. I could have understood that I am trying to make an interpretations of my own. Can the states say that I will fill up the promotion?
But not I will not
Yes.
from the zone of.
I'm not asking give it to me. I say give it from the zone of concept. What they are doing is, they are, my lord, doing this.
Right, Mr. Dhar, we understand that. In 2019, it was directed they may consider. We don't know what was the reason for might consideration.
Correct. But that's the order of the learned tribunal.
Right, that
But
has not been interfered.
No, I'm not saying that that is the only my reason. Other reason is rule itself. May I show that? Kindly have a look at, my lord, page.
That the tribunal will adjudicate.
My lord, they will adjudicate finally. I'm not seeking.
Is subject to the result of the original.
My lord, that is. May I show this? My lord, may I show this? Thereafter, my lord, I will not renew.
Reject your prayer, you would be more prejudiced.
No, my lord, I am aware of that. May I just make this try? May I show page 119?
Yes, are you?
I'm appearing on behalf of the state, your lordship.
Any further promotion is being given?
Well, I have said they have sought, because nobody gets to know that who would be promoted when. I say that if you are going to promote 5%, then 25% get a chance to say that please consider my experience. Not only because of the tribunal's order, but also because of the rule itself.
We understand that if they do not follow that,
Yes.
and if they make any promotion,
Yes.
that will be contrary to the regulation and which will be open to challenge in the original
But I
application.
have already challenged that. And if I'm successful, then they have to.
Court has not rejected your interim order. Tribunal has said that I am calling for the details. I will
Yes.
hear it.
Well, may I make this prayer in that case? I understand. May I make this prayer? Would your lordships kindly have a directions? May I seek this for a preponing of the date for the purpose of interim prayer at least?
Go and make a preponing application.
My lord, that is the reason, my lord. Kindly see that at page 274A. Kindly have a look at this. That last but one paragraph. That was on 9th of May. Kindly see last but one paragraph. Prayer of Mr. Ray for interim order will be taken up on the next date of hearing. So, my lord, thereafter,
Will say you will make a preponement application, they will consider.
for the purpose of interim order. That's because they don't want to follow this 82 rules. They don't want to follow the zone of consideration. My lord, lordship may not.
Yes, Mr. Dharma.
Well, I was saying, let that matter be fine.
It's better you withdraw file a preponement application.
Sir, I'm not asking preponement after this. What I'm realizing is, let me, because since the reply is there, let the matter be finished there finally. I'm only seeking, my lord, kindly have, my lord, one sentence that, my lord, let it abide by the promotions in the meantime shall abide by the
That
result
will
of the
always
audit.
abide. Affidavit of service filed by the petitioners be kept on record. Mr. Dhorland and senior advocate appearing for the petitioner submits that the documents annexed submits that the respondents are taking further steps towards promotion without taking into consideration the notification dated 22nd October 1980. And as a consequence thereof, the petitioners would be the worst sufferers. Stop. Mr. Thord has also drawn our attention to an earlier order passed by the learned tribunal. Same petitioners? No.
Some, yes, my lord. same
OA
way.
628 of 2017, wherein the learned tribunal inter alia observed that quote unquote, the experience of the applicants, the experience of the applicants as nursing personnel in West Bengal such with lateral induction in the cadre of cleaning may be considered in terms of such and such contention of Mr. Dhod has, however, been disputed by Ms. Sinha learned advocate appearing for the state respondents, and you are for who are those who are আচ্ছা দিয়েছে and Mr. such and such learned advocate appearing for such and such. Stop. Records reveal that by an order dated 9th of May 2024, the learned tribunal admitted the application with an observation that and made the matter returnable for hearing on 13 June 2024 for consideration of the prayer for interim order. Consideration of petitioner's prayer for interim. Stop. Thereafter, on 13 June 2024, the learned tribunal further fixed the matter on 28 November 2024, calling upon the respondents to file a reply mentioning how many from the reply mentioning quote unquote mentioning how many after publication is advised to file were promoted to the post of senior lecturer after publication of the gradation list, and also indicating the reasons regarding non-consideration of promotion to the post of senior lecturer for these two applications. In the said conspectus,
But the allegation was that the Pinky Ghosh, having secured higher marks, was not called for interview. And they come up with a Milord stand. It reveals little more.
Paragraph.
Milord, the page 54. This document they have annexed. Now, Milord, they mark Milord Pinky Ghosh, which is item 13, AB. I have never seen in my little bit experience Milord, in this field that absentee is written as capital A full stop B.
Pinky Ghosh is not a party here. Pinky Ghosh has been added as a party, or she has filed a fresh petition.
Added hoyeche ekhane. Added as a party.
She has been added, all right.
Now this Pinky Ghosh Milord marked as AB, and noticeably you will find the person who has put in AB the same person.
No,
I mean, it must be office clerk or somebody else.
this is page 50.
This is the candidate's attendance sheet.
This is at the time of personality test.
Yes. দাঁড়াও না বলতে না এত ছটফট করো কেন
Page 50. So you are saying that this is an erroneous marking. She was present, but she was not.
She was not at all called.
For
They
the
have-
personality test.
They have to demonstrate that my name was appearing at the interview list. They have intimated me. I did not appear, then I am absent. But they have to Milord, first to be satisfied that I was called for the interview. In spite of calling, I did not appear. Then only I can be marked as absentee, otherwise not. Well, let them produce the interview list where they can demonstrate that my name was there. And the presumption goes that she was called and she did not appear. But everything is mismatched.
No, Pinky was not there in the interview list also.
At all. My allegation was that I secured higher marks, still I was not called for interview. And reply to that, they wanted to show that I was called and I didn't appear. On the ground of Milord, the reservation and Milord, upliftment of a candidate because of higher marks, Mr. Shanigal has argued a lot. I am not going to add to that. Except that Mr. Shanigal has argued the issue very correctly so far the vertical reservation is concerned. But the similar problem with regard to Milord horizontal reservation, so male, female. If you give credit at every stage, then it becomes multiple benefit. As per the Indira Jaising judgment, which has been placed, I am not going to waste my lord's time. At the final level, if someone, Milord, marks equal or higher than the general candidate, then person should be lifted so that that vacancy which falls would be benefited to others. That was the reservation theory, so that the backward people can come forward and they are not deprived. Well, these are my humble submissions, Milord. In reply, I don't want to add anything more. Well, I would again, Milord, appeal to your lordship, Milord. The process, if it is found to be tainted, Milord, this is not a rearing case here and there. In state of West Bengal, now it has been spread to throughout the country, I find. Only the constitutional court can, Milord, rein them and bring them back to the principle of truthfulness. That's my humble submission.
No, Mr. Bhattacharya, you are summarize if you, one was you argued about reservation. Reservation and vacancies which were created. First day you argued. These two arguments and this is your next one. Yes. Yes, Mr. Bandyopadhyay, you want to say anything?
Mr. Mitra?
Oh, yes, yes. Yes, Mr.
Your lordship has been pleased to hear the argument of the learned counsel, my lord, over and over again. My lord, I do not want to unnecessarily burden your lordship with a repetition of my submissions, which I have made already. But the basic submission that I want to make before lordship in reply is that if I can demonstrate there had been a violation of the rules, then my lord, the commission is obliged to, my lord, satisfy your lordship. First of all, that there had been no violation. And if secondly, if there had been a violation, why there had been violation. My lord, I will just draw your lordship's attention to, just by way of refreshing your lordship's memory, rules 8 and 9. Well, of the notification dated 20th September 2016. Well, these rules have been placed before lordship over and over again. I will just draw your lordship's attention to this. Kindly note one thing, that these rules 8 and 9 are repeatedly using the term the number of vacancies. Kindly, my lord, take rule 8 once. Motion. 8.1, rule 8 is information regarding vacancies. Sub-rule 1 is the district inspectors of school secondary education shall, on being asked by the director of school education, prepare a report regarding the number of vacancies in the post. Because the vacancies will depend this 1:1.4. Your lordship will please to recall. So, my lord, this vacancy is, my lord, rule 1, it starts off with this. The inspector of schools, district inspector of schools shall inform the number of vacancies. Then, my lord, it just goes on. I am not going to trouble your lordship with sub-rule 2. Again, my lord, vacancy report. Kindly, my lord, see sub-rule 2. On receipt of the report, the Directorate of School Education again will have to prepare and send subject-wise, group-wise, medium-wise, gender-wise, reservation category-wise, vacancy report. Compiled region-wise, earmarked vacancies in such posts, if any. Then again, my lord, the sub-rule 3 also there, also the date of publication, I am not troubling your lordship. Kindly come to rule 9, sub-rule 1. Central Commission shall, on receipt of the report of region-wise vacancies under Rule 8, issue an advertisement. Therefore, the region-wise vacancies is the, so to say, the basis on which, my lord, an advertisement through newspapers will be issued. Then sub-rule 3 is very important. While specifying the vacancies in the advertisements, the Central Commission shall, for the said posts of such teachers, publish a tentative number of vacancy. This is the first one. Tentative number of vacancy at the time of inviting application for state level selection test, SLST. That have been reported under clause A of sub-rule 3 of rule 8. And a final vacancy list at the time of publication of the interview list. So, my lord, the vacancy list, my lord, kindly see at every stage, this vacancy list is, my lord, is being emphasized upon. And ultimately, my lord, the final vacancy list at the time of publication of the interview list. Now, my lord, keeping this in mind, kindly come to rule, this very important rule 12. Kindly come to sub 12. First is, my lord, Central Sub-rule 2, the Central Commission, after receiving application forms, shall prepare the list of eligible candidates for the purpose of preparation of a computer-generated database of all candidates. Then 3, the Central Commission shall verify the validity of the TET certificate. This is with regard to, my lord, the verification of the different certificates which have been produced, which shall be evaluated. Then 4, the Central Commission shall prepare and publish in their website interview list with all details of the candidates to be called for personality test category-wise on the basis of the merit as mentioned in Part A of Schedule 2 in the ratio of 1:1.4. Now, my lord, therefore, at the time when, my lord, the interview list will be prepared, this ratio will be maintained 1:1:4. My lord, my respectful submission is this: if your lordship reads this Rule 5, Sub-Rule 5 of Rule 12 with Rule 9 of Sub-Rule 3, the final vacancy list at the time of publication of the interview list. So if this is not there, then, my lord, the interview list is not complete. It will be a defective interview list. So this 1:1:1.4, this particular ratio, when you apply to the facts of this case, that means, my lord, the vacancies that you have obtained, if it is not a complete vacancy, final vacancy list, not tentative, final vacancy list, then, my lord, in my respectful submission, the list, interview list prepared is a defective interview. That's the first point I made. In this connection, I would.
Your argument is that ratio of 1:1.4 must be in respect of the final vacancy which is called for in under section
Because
9.
the rule says so. I am not saying anything extra.
So before the final vacancy is disclosed, if it is not disclosed,
The
then
interview
the
list
ratio
cannot come.
becomes bad.
That is my short submission, your lordship. Well, I just want to draw your lordship's attention in this regard. This submission I have made, and that has been, my lord, is in my submission on behalf of the appellants. Paragraph, kindly, my lord, make a note of it. This is exactly what I have submitted, summed up my submission. That is in slightly, I should say, in a more elaborate way, had been mentioned in paragraph 13 of my notes of submissions. Then it will be easier for your lordship to follow my submission. Notes of submission, my lord, it's titled corrected copy of the list of dates and written notes of submissions.
না এখান থেকে আমার বিলকে ফিরে নিয়ে
আচ্ছা, এবার আমার
থেকে আমার
কোথায় গেল? মানে ইয়েটা কোথায়?
পরীক্ষাও না এটা কোথায় গেল?
উপরে কোথাও কালি হবে, তার উপরে তার তলায় উপরে পৃষ্ঠা দাও না, কালি হবে। এই জিনিসটা
তুমি এখানে লিখেছো?
আমি এটা তো তোমার ওখানে রয়ে গেছে। না না, উনি অন্য জিনিস করেছেন, উনি এটাই প্রেস করছেন। না না, এটা তো আর ইউ প্লেসিং দিস ওয়ান মিস্টার?
Yes, it looked right. Yes. There, my lord, kindly come to.
দেখো দেখো, আমারটা তো আমি নিয়ে গেছিলাম।
The lordship has got that.
Yes.
I just want to draw your lordship's attention to the submission I have made as recorded in these notes of submissions. Page 13, subparagraph 4, Roman 4.
Yes.
Violation of rules 8.3b and 9.3 of the rule of 2016 on the part of the commission takes place for the non-including up to date vacancies in the final vacancy list published by the commission, and thereby also violating Rule 12(4) of the rules of 2016 by not calling candidates for interview on the basis of 1:4. Exactly my argument. This is summarized. Final vacancy list as published by the commission is contrary to order dated 11 December 2020 of this honorable court and violative of our rules 8.2, Rule 8.3, Rule 9.3 of the rules for the following reasons. 1. List of final vacancies not published 15 days before the date of publication of the interview list as per Rule 8.3b of the recruitment rules. 2. Final vacancy list published by the commission in contravention of the requirements of Rule 8.2 and Rule 8.3b read with Rule 9.3 of the recruitment rules 2016 as no report obtained from the Director of School Education as to the number of vacancies available subject-wise, medium-wise, gender-wise, and category-wise prior to the publication of the final list on 21st June 2020. And this is evident from the 2 points, namely in the advertisement published in the year 2016, total vacancies declared was 14,088, including 10% para teachers of the vacancies, whereas in the notification dated 21st June 2020, the total vacancy disclosed to be 14,339, excluding 10% para teachers. And therefore, there has been an increase of only 1,660 vacancies between the period of 23rd September 2016 and 21st June 2020, publication of the final vacancy list. Then, my lord, inclusion 3, and this I shall show to your lordship. Inclusion of only 1,660 vacancies during the aforesaid period of almost 5 years is not correct and violative of the aforesaid rules 8.2 and 8.3b of the rules of 2016. As the learned advocate for the commission, by letter dated 11th August 2020, informed the Honorable Chief Justice of this Honorable Court while praying for constitution of special single bench for hearing the writ petition as to the existence of 5,001 more vacancies reported to the commission in the meantime.
Yes.
And also the commissioner's school record. This, my lord, is your lordship, just for the sake of record, your lordship can note this particular 11th August letter is, my lord, annexure P14, page 230 and 231. Pages 230, 231 of the petition, of the stay application.
Which stay application?
Stay application.
Rajiv,
Rajiv, this is my lord, the Rajiv Brahmo stay application. This thing.
This I have already placed before your lordship. 2 letters I have, 2 documents I have placed in this connection. One is at page 230, at 231.
Page 231 and
230 at page, my lord, the letter starts at page 230, Bosho.
page 230.
Yes, 11th August 2020, which has been referred to in this paragraph, which I just now placed before your lordship. Page 230 at 11th August 2020. There, your lordship will, I am not going to trouble you. Learned advocate had written, it may be mentioned, the first paragraph at page 231. It may be mentioned here that though the final merit list has already been published in the selection process, in the said selection process, with the kind leave of this honorable court, counseling and recommendation could not be made due to the subsisting restraint order passed in the above matter. It is pertinent to mention here that after the initiation of the said selection process, about 5,100 more vacancies had been reported to the commission, but due to existing bar in the relevant rules, those vacancies could neither be included in the present selection process, nor a fresh selection process could be initiated by the commission pending completion of the present one. This is one, my lord, we received from very authentic source, namely the advocate for the commission. Then, my lord, kindly turn over the page. Page 232. This is dated 15th February 2019. And publication of the list was 2020. Publication of the final list, 21st June 2020. My lord, your lordship remembers. that.
Yes,
And my lord, this is a letter dated,
11th of August.
no, the next letter, 15 February. That's not the end of the story.
That you have
15
referred to in which paragraph of your notes?
written notes, I immediately I shall show to your lordship. where-
Already, sir. That is at page 232.
Yes,
What is the date of that letter?
letter 15 February 2019.
Very.
And publication of the final list is, final vacancy list is 21st June 2020. So this is before that date. This letter also, with reference to the subject, at page 232,
That there were far more existing vacancies.
Existing vacancies.
That
So,
you have asked.
once, my lord, the vacancies have been shown, and this is, my lord, what I have stated in this paragraph, what the vacancies have been shown to exist before the publication, I mean, after what has been stated to be the final vacancy list, if it is shown that there were more vacancies, and this particular vacancy, the last one, is by reason of, my lord, new schools having been established,
Yes.
new induction of new teachers.
So that also ought to have been brought within the purview of
Yes,
CCA.
yes,
That
yes.
was your argument.
Yes, and my lord, this, for that reason, I also showed to your lordship, kindly, man, just I reminding your lordship, the definition of vacancy in the regulation, definition section. My lord, kindly note definition section,
Yes.
regulation 2
2E.
or rule 2, 2P. And but the first one is I, creation of a new post. So vacancy means
It
a
includes
vacancy in the
new-
post of teacher,
It includes new vacancy, creation of vacancy.
creation new post, and that is page 232. So this is my first submission, just
Yes.
by way of I don't want to trouble your lordship anymore on that. And the only other submission that I make before your lordship is this. And I have also made this submission just by way of
reiterating what I have submitted, that, my lord, the migration in respect of
Migration of
Yes,
vacancy.
my,
that
I have already
you
submitted.
have argued.
I have
Just
argued
one
that one, and
paragraph
it is contained in my notes also, written notes of submissions also.
written.
Yeah, the one that is just now your
Yes,
lordship,
yes, we got.
it is there. So, my lord, these are my respectful submission. Only one decision which I wanted to, I think I placed it before lordship. I don't know whether I did or not. Just one,
Indraswani.
2 paragraph. This is, my lord,
I think it is there, with lordship. Hemraj Singh Chauhan's case.
Hemraj Singh Chauhan's case. This is 2010 4th Supreme Court cases, page 200, and these 2 paragraphs are, I thought that perhaps they will be important. Is, my lord, judgment decision, my lord? or-
This was placed by you on the earlier. or
I don't remember. I tell you, lordship, it is so long
Mr. Vito,
ago.
can you give us
it has
the
escaped.
citation? please?
My lord, citation is 2010 4th Supreme Court cases 290. A division bench judgment of the Supreme Court, my lord, the judgment was given by Mr. Ganguly. My lord, paragraph 36 and 36, 37, 38. Very short paragraph. I'm just reading it out.
This
Well,
is
I'm
on
sorry, my lord, I can't.
what proposition? Mr.
Proposition is this, that this adherence to the rules for the preparation of vacancy list and thereafter application of Rule 12 is a part of a fundamental right which is guaranteed under Article 14 and 16 of the Constitution. So any breach of the rules is in fact, my lord, breach of the provisions of law. And my lord, this is what is said. May I just place it
Yes.
for your lordship? Very short paragraphs of 3 paragraphs. It is an accepted legal position that the right of eligible employees to be considered for promotion, it was promotion, is virtually a part of the fundamental right guaranteed under Article 16 of the Constitution. The guarantee of a fair consideration in matters of promotion under Article 16
virtually flows from the guarantee of equality under Article 14 of the Constitution. Then paragraph 13, that's exactly what I said. I have forgotten whether I have cited or not. তোমার মেমোরি আমার থেকে অনেক ভালো, সেই জন্য তুমি ওষুধ তো আমি তো এইটুকুই বলছি, আর কতটুকুই বলছি। মানে very difficult to control, my lord.
Mr. Victor, you take up this issue outside court.
The only way I can control him is by offering tea or something stronger. Nothing short of that.
Yes.
Then, my lord, I said, it is therefore, it says the government branch press by Beliappa, a 3-judges bench of the court in relation to service dispute, may be in a different context held that the essence of the guarantee epitomized under Article 14 and 16 is fairness founded on reason. And then paragraph 38, it is therefore clear that legitimate expectation of the respondents of being considered for promotion, I said appointment, have been defeated by the acts of the government, and if not the central government, certainly the unreasonable inaction on the part of the government or state of Uttar Pradesh stood in the way of respondent chances of promotion from being fairly considered when it is due to such consideration. My lord, your lordship will kindly note the language of Article 16. It is with regard to appointment and promotion. Article 16, sub-article 1 is talking of appointment and promotion. So this particular judgment is in respect of promotion. I say that it's equally applicable in respect of appointment. And if there is an infraction of the rules which, my lord, should govern, my lord, the authority is concerned for the purpose of this. If there is infraction, then, my lord, it's violation of Article 14. These are my responsibilities.
Yes, we want to know.
Yes, I have seen that the Bhattacharya is referencing.
Mr. Dr. Patra, have you got the? Yes.
No, so far Mr. Mitra's argument is concerned, already I have covered in my argument with great respect. It's just, but I have a serious objection regarding the supplementary affidavit which has been placed before a lordship. But I have no objection up to paragraph 1, 2, 3. Paragraph 3 is concerned because. ও স্যার প্লিজ, আপনি বসলে আমি ধন্য হয়ে যাবো। একদম করবেন না, আমার মতো ফ্রেন্ড কোথাও পাবেন না খুঁজে, বুঝতে পারছেন না? বিপদে আমি থাকবো, বিকাশটা থাকবে না, আমি থাকবো কিন্তু না ফ্রেন্ড জলখাবার হওয়ার মতো আমার ক্ষমতা।
যখন বিপদে পড়বেন তখন দেখবেন আমাকেই পাচ্ছেন, বিকাশটাকে পাবেন না। ওরা হচ্ছে
আমরা হচ্ছে মাটির লোক, ওরা হচ্ছে উপরের লোক। না মিলাট কাইন্ডলি সি আপ
জাস্ট 1 মিনিট। সাপ্লিমেন্টারি এভিডেন্সটা দেখালো না, সেটা প্যারাগ্রাফ কত দেখালো? প্যারাগ্রাফ 70।
আপনি একটা যেমন লাল
17টাই দেখিয়েছিল
আরএসএস আমি তো চিরকাল এমন রামচন্দ্র করতে গেল না।
Yes. So far supplementary affidavit which has been produced, Mr. Bhattacharya has placed that today in Rajiv Brahmo's matter. But so far paragraph 3 is concerned, your lordships wanted to know some information that there, and your lordships asked them to file an supplementary affidavit. Therefore, I have no objection. But taking that advantage, what they want to do, kindly come to paragraph 4. This is beyond the scope of the petition, appeal, and etc. He is trying to bring, Milord. Yes. Certain facts which are not German, which are not involved in this matter, which are not. That was not kindly remember from the very first day I was making a submission before a lordship. See, what was the case? What was the prayer? First, see the law pleading. That kindly remember that, my lord. Now,
your lordships have heard it, affidavit is called for. Now he is going beyond everything, taking something, my lord, kindly see the paragraph 5, 4 and annexed an affidavit. That's similar at page 5. That's a Bobita Sarkar's matter, and affidavit has been filed by the CVIB in that matter. And this has nothing to do with this matter, my lord. This is simply an attempt to prejudice the court, nothing more than that.
This was pertaining to the same selection process.
No. This is pertaining to the, my lord, selection of class 9 and 10 conducted by SSC. Not this. This affidavit is not connected with any of the proceeding here.
No, this paragraph 17, which Mr.
That's right. That is the paragraph. Kindly come to page 5.
Page 5.
5. It's a matter of Bobita Sarkar.
Just tell us that was not relating.
Not relating to upper primary.
Where do we find that? Page 5.
Page 5 is there. Kindly see the cause title. Page 5 of the affidavit.
That was in respect of which selection process, Mr.
In respect of selection process of class 9 and 10.
Of secondary schools. 9 and
11, 12 of the secondary schools.
Then why they are saying it is upper primary?
No. In the report, they have submitted a report there. In that
there are illegalities in the upper primary.
No, that has not been said. They have referred to upper primary. Kindly read this.
Yes, paragraph 17.
Paragraph 7. That investigation established that as a reward for doing aforesaid manipulation of the OMR score means manipulation, alleged manipulation in respect of 11 and 12. Not manipulation of the upper primary.
That was selection process of which year, Mr. Bandhavatan?
2017, 16. That was also 2016. But 9, 10, 11, 12, C, group C and D. Now see, comma, Messrs. NDISFL of Nilati Das was provided work of recruitment of teachers in upper primary conducted by WBCSA. Apart from this, many other recruitment works also assigned to Niladila by the government of West Bengal. Various lists of candidates related to upper primary were communicated Niladila, Swanso, Sormila, etc. were found to be email. There were 2. Kindly see, because according to CBI, since this Niladri had made manipulation in the selection process of 9, 10, 11 and 12 and group C and D, he has been given appointment, he has been given again a contract to conduct the, but that has nothing to do. Upper primary is not saying upper primary selection process is bad, OMR seat is bad. Completely true. This is only to Millard. This is the there.
They are pointing out that this Niladri was there in a process.
Maybe there.
Stuff. Now they
maybe there. Question is, Millard, it has to be established.
We follow your
now. So far, just I give you a lot since it has been referred to 9 and 12, 11, 12. Ultimately, Millard initially went to up to Supreme Court. Supreme Court directed that this High Court should decide the matter within a parameters and Evidence Act 65B, etc. Calcutta High Court Division Bench has set aside the selection process, entire all selection. That is Justice Bosak. That went to Supreme Court. Supreme Court has stayed the order. Matter is pending. Now there are serious questions are involved. 65B B of the Evidence Act has been followed or not. 45A of the Evidence Act has been followed or not. So many questions are there. How it can be linked up with this matter, my lord? Simply because matter is pending for years, my lord. Kindly do not mind, my lord. It's pending. He can't take an advantage.
Yes. We understood, Mr.
But there's nothing. It has no relevance. My lord, my humble prayer, my lord, from the very beginning, I am saying, my lord, kindly see what is the case and what is they are trying to achieve.
We have argued that.
I have argued that. And my lord, today also Mr. Bhattacharya was saying about this. My lord, I have already argued, my lord, some errors, either this side or that side, will not, my lord, vitiate the selection process itself.
That you have argued.
That's a
volunteer also.
My lord?
Civic volunteers.
Civic volunteers case also I have argued that matter, my lord.
And Mr. Bhattacharya was opposite.
My lord, one of the important thing is this. My lord, this is even anyway, just I am saying, my lord, their judgment is also there 2020. My lord, court's attempt would not be to set aside the selection process.
Yes.
Let's assume some illegalities have been committed. Let's assume for the time being that what is the court's duty to do, which has not been done by in another matter by Justice Bosak's bench, which we have taken the point in the Supreme Court. Court's duty is to segregate. Let's assume that your lordships are coming into the findings. These are the arena. There the selection is bad. Whole entire selection process will go or will segregate. That's the question. No, nothing. I do not want to add anything, Milord. So deeply obliged, Milord. Only one thing to say, Milord.
So on the judgments which you cite,
Milord, I have given a written note. Yes.
Mr. Sarnal, your list of judgments, can you?
I have also handed over the compilation also.
You controverted the judgments which were relied upon on behalf of Mr. Mukherjee. And what were your list of judgments there? If you can help us with that, the respective parties, just to
নামটা লিখে দিত তো আমার নামটা লিখে দিলে Milord, I have handed over the compilation itself.
We shall get
Milord, they will try to find out. It will take time.
On the other, we are having this file of.
I know, understand, Milord. ওইটাই কোনটা ওইটা দাও তো দেখি একটু
You have annexed any compilation? Show us the compilation.
Milord, kindly take this. If required, I will give another.
No. The Sadananda hello to.
Sadananda hello is an item serial number 1. কোথায় এগুলো কোথায় apart from that compilation, Milord,
this is your compilation.
Milord, apart from this compilation, 2 other judgments I cited and it was given. Milord, I will give it.
Just check up. Just let us check.
Check up করতে দাও কোনটা কই একবারে কেন যে করিস না
That was 2018 volume 16 SCC.
2018 volume.
There was no RTDR motive.
Milord, is it no
93 supplement to SCC.
No, Milord, I have cited 2006 volume 3 Maharashtra Law Journal.
Oh, acha.
That is Milord, Chief Justice F.L. Rivellero and Dr. D.Y. Chandrachud in the Bombay High Court. 100-point roster system.
Acha, you please give us that.
There, Milord, that is just for the proposition. The petition normally could not have been considered for future vacancies unless there is a rule providing for appointment. And even if that rule is there, that must
yes, 2006 volume 3 Maharashtra Law. Another you referred 88-4 SCC.
18-4 SCC. Yes, these are the. These are nothing more than that. Deeply obliged to lordships.
Yes, Mr. Bhattacharya, where is your compilation of judgment?
My copy is already there.
Mr. Shamim, can you help us with that? একটু দেখাও না ওই। Can you help us which one was your compilation?
Yes. Law notes. পরে বার করে দিও কোটেশন আসলে পরে বের I will give three not one Nasrin Khatun and another. আরে ওই বকে বলে কি হবে বার করে দাও ইন্ডিকেট করে দাও।
Please help us. This is not the judgment. These are not the judgments. ওইটা আমার এটা নেবেন।
আমাদের ওরকম সিমিলার একটা ল নোটস আছে এর আগে বের করছেন আপনারা
এটা কোথায়
হ্যাঁ এইটা
এই যে উৎসব আর্গুমেন্ট যেটা আর্গু করলেন না এটা আছে এটা আমার সাপ্লিমেন্টারি ল নোটস তুমি কি নামিয়ে নিলে তো আমাকে যেটা মিস্টার ভট্টাচার্য আর
item over.
Yes.
Then item number 52. Would it be called on today or any other?
Same,
Same group. This is only respectable of the untrained candidates.
So that we will consider it.
My lord, my compilation I have submitted on 14 March, my lord, and I concluded my argument.
Let us
Yes.
do one by one, please. Yes, Mr. Bhattacharya, you may. Please,
I will assist. I will assist. I will assist my lord.
Then you mention that. Just
But I will mention, sir.
yes, give
Sir,
your name and mention those judgments. Ajay, Mr. Sannal, have you given us that?
I'm just giving a losses.
That must be in our file.
But I'm giving a losses, my lord.
Yes, least we will find out if, or we will call upon your junior tools. Yes, Dr. Patra, you explained to us about that Aditi Rai.
Yes.
Which Mr. Sannal pointed out on
Yes,
the last.
Before that,
And of this absent marking in respect of Pinky Ghosh.
yes, yes. Before that, may I just mention one thing with regard to the supplementary affidavit which they have filed today. Mr. Bhattacharya was pointing out paragraph 17 that the court should not take note of it. In addition to that, I am adopting what Mr. Kallan Bandyopadhyay has submitted with regard to the affidavit. But in addition to that, I would like to just point out one fact.
তুমি তিনটে এখানে কমিশনের আর কল্যাণ
Paragraph 17 of the report of the CBI,
Yes.
where they have stated
Yes.
that the investigation establishes that as a reward for the aforesaid manipulation, etc. But this observation is totally incorrect. Though this is not the place to argue this point, but since this has been brought out, because upper primary assessment of their TET OMR answer scripts was done in 2015. That is prior to the 11-12 selection process. Yet they have come up with this observation, which is chronologically absolutely absurd.
Upper primary was 2016.
No, but the TET examination, the teacher eligibility test, the OMRs which are under question, that was 2015. And it was prior to 11-12. It was prior to the 11-12 selection process. So this observation that it was a reward, this is disputed and
All right.
and this is, I'm only submitting in addition to what Mr. Bandyopadhyay is saying.
All right. Yes.
I'm also opposing them relying upon this evidence.
You show me that, you show us that mark which Mr. Sannal showed us. That
Yes.
marking.
Yes. With regard to the Pinky Ghosh, the issue.
Come to his page. This one, his law notes.
Yes, yes.
পিঙ্কিটা কোথায়? ওটা কোথায়? এটাতে আছে। না, absent. আবার কি দিব? No, no, not that, Mr. Dr. Patra, this one. Mr. Sannal filed this one.
Oh.
Not in that. That is page, এটা কারা? Page 17 of that. Page 17 of that. Aditi Roy.
Yes.
এটা দেখো ওরা একটা না, যেটা প্রথমে আমার কাছে গেছিল আরেকটা লিস্ট এখানে ছিল, যে এরকম সাইটটা কভার করা থাকে। হ্যাঁ no, Rajiv Brahma was at that 705 or something like that. You showed us na these two documents.
Yes, yes.
Maybe that.
With regard to page 17, 18, and 19, which
Yes,
Mr.
yes.
Shanal showed on the last day, 4 candidates, Aditi Poulumi, Sanchita Saharoy, and Achinta Kumar Mukherjee. These were the candidates. At page 17,
Achinta, not Poulumi is there. Poulumi
yes, that is page 17. Page 18, Poulumi Chatterjee, Aditi Roy is page 17.
Yes.
And page 18 is Poulumi Chatterjee and Sanchita Saharoy.
Right. And page 19 is Shikha Ghosh and Purvasha Banerjee. Achinta
No,
Kumar.
third one is Achinta.
19.
Yes. Page 19, the last.
Achinta Kumar Mukherjee.
Yes. I've taken instruction with regard to the Aditi Roy and Poulumi Chatterjee. They are both in the list of 74 candidates. Those who had defaced OMRs, but after re-evaluation, their marks were still not matching with the server marks.
So they were within those 81 who had been left out.
Yes, yes, yes. Yes. Later on, it was calculated to 74 in our law notes. 81, next to 81, it is mentioned 74 in the bracket. Kindly see our law notes.
Yes. So this Aditi was in that 71 group.
74 or 70. My lord, it will be 74. Kindly see page 15 of our law notes.
Yes.
The fourth box from the top. Candidates who still. Page 15 of the law notes.
Yes.
The fourth box on the top, 81, next to it in bracket 74.
Yes.
74 is the final figure. 74, this Aditi Roy and Poulumi Chatterjee, they fall in this category. The category is candidates who still had mismatch on comparing marks of rechecked OMRs.
Where from are you reading?
My lord, page 15 of our law notes. School service
candidates who still had mismatch on
Yes.
comparing marks of recheck to MRC. Now,
Yes.
who were included in that? Aditi?
Aditi is there and Poulumi Chatterjee.
Very good. So, Aditi, Poulumi. Now, I put Sanchita.
And Sanchita Saharoy and Achinta Kumar Mukherjee, they are in the list of 559 candidates who had a pure mismatch of marks, no defacement in their.
Who were removed?
Yes.
By the earlier, no, that was 233.
They were the candidates who had a pure mismatch of marks. The marks in their OM
was from your list, page 17.
Yes, page 70 we have dealt with in our page 51 of our law notes. Kindly see.
About 51. Page 51. Poulumi Chatterjee, Achinta Mukherjee. Yes.
Now, from the top, which is Aditi Roy is the first candidate here, serial 7. Poulumi Chatterjee, Sanchita Saharoy, The next column is the allegation, not called for PT, though having sufficient marks. Then the
No, we are asking Mr. Dr. Pathur, these persons who have been noted, come to the page 15. Come to your page 15.
Yes.
At the top, 559 mismatch of marks.
Yes. That is the Sanchita Shaharoy and Achinta Kumar Mukherjee. They are in this list. They had a pure mismatch of marks. There was no defacement of
That
their.
is not telling with your page 54, which you just now showed us. Achinto said called in first PT, rejected later due to decrease of TET marks during weight.
Yes, decrease in TET marks because of the mismatch. Because of the, say the server is showing.
So this 559 is within 1463.
Yes.
Yes, yes.
These 559,
Yes.
74,
Yes.
etc.
Yes.
All are within
Yes,
1463.
yes.
That is the total number of candidates who were initially ousted upon rechecking of
My lord.
re-evaluation
My lord.
in derogation to earlier court's order. This was their
My
submission.
lord.
Now, out of this 1463, how many persons were ultimately left out? Because you thereafter called 902 defaced OMR. You called more than 800 persons again.
My lord, ultimately 633 candidates were left out.
Where do we find?
My lord, before that, let me just.
এইটা পাচ্ছি না। হ্যাঁ
74 plus 559.
আচ্ছা 74 plus 559 তাহলে কত হলো 9 4 13 6 6 12 13 633 candidates.
Yes.
So out of 1463, 633 were left out.
Yes.
And the remaining were
Yes.
there. Huh?
Yes.
And now what is your existing vacancy?
The existing vacancy, my lord, is.
That is more, about 100 vacancies are there, na?
No. Total vacancies.
Total বলছি না কত
Total persons attending. Candidates confidential. Final vacancies 14,339.
Out of that 1,333 were called.
Yes.
Page 16.
Yes.
So total was 14,000
339.
14,339. And out of that 1,333 filled up. That means a found place.
Merit list. That is the total size of the merit list.
Yes. So vacancy থাকবে 0 1000 ছয় vacancy ভ্যালুও তো বেশি vacancy যতগুলোকে বাদ দিয়েছে 630 Son of exclusion of 632. হচ্ছে 1300 দিনা 4300 sorry 14 sorry All right. Anything else? Ashok, the learned advocates appearing for the respective parties have concluded their arguments. Judgment is up. আবার কি হলো?
My compilation. My lord, I appear for NCT in all these matters, Lordship.
We are very happy to learn that. You are? Where are you?
Lordship, my video is not on. That's why I'm just putting it on, Lordship. Lordship, I was silently participating, Lordship, because I was just listening to all the submissions.
Junior. Is your junior here?
Yes, Lordship, she has been there.
So can you give us the details so we will find out your junior? Where is your junior?
Subject to Lordship, correctly.
Lordship, I have started my camera, Lordship, with the Lordship's kind leave. Can I appear for NCT in all these matters, Lordship?
All right. ওনার নাম নিয়ে নিও। এই আশা গুটগুটিয়া NCT হয়ে গেল? ঠিক আছে। Yes, what are you?
They all are fighting because of the regulations.
They will be
Yes.
For my learning friends, I make one thing clear, because they are repeatedly saying that Aditi, Paulomi, Sonchita and other one that sent, they were not called for interview. That's incorrect. They were called for interview this time also. After the interview was held, they were kept out of the merit list. They were within, my lord, 14,000 and odd.
Very good.
That's similar. That's
They are within 1463, but they were
no, not 1463, 14,000 and odd. Those who are called for interview. Your losses kindly, this should be clear to your losses. Otherwise, this will be factually mistaken. My lord, kindly will look at page 15 of their notes. That's they are not correct in saying that. Your losses kindly will look at page 14. No, 14 first. But kindly at the top, your lordships.
ওটা বের করো না, ও কোনটা কম্পাইলেশন বলছে বলো। which is your compilation? এটাতে ওনার নাম লেখো। এটাই কিনা দেখাও, এটাই।
Yes, madam.
ওনার নাম লেখো ওখানে উপরে বোল্ড করে লিখে দাও। Yes, what you are showing?
Now your losses, page 14. 15 and 14, 15 comes before that page 14.
Yes.
But kindly will look at lordships. At the middle column, little bold letter, interviews personality test. Has your lordship got that one? 15436. Persons who are called for interview before grievance hearing. And then 12,007 persons who appeared in interview. But kindly come to bottom. Total persons attending the interview, 14,052. We were within this time also. If your losses wants, I can show my interview later also. I have.
So your contention is in 14,052.
We were there.
We were means which part? Name the persons.
Aditi, Paul. These are the instances.
No, Aditi is not a party in Brahmo.
Yes, it's a Brahmo party. He's an added respondent. Or your lordships.
Aditi,
Paulomi, Sonchita and other name Ochinto. All the parties.
Paulomi, Ochinto. So, and another name is there.
Sonchita.
You were there in this 14,050 candidates.
So my name was in the interview list.
Now they are showing us that.
Next page 15.
No, you were not. Which page you showed us, Dr. Patra, which page you showed us?
My lord.
As regards Polomi.
51 probably.
Page 51.
51. Unta
Kindly see your lordship, clause 7, Aditi Roy. Right hand side called in first page of PT. But PT was only once.
First page 51. No?
51.
51.
Just now probably my learned.
Yes.
Well,
He was
kindly see
not
serial
called
number
for
7.
Not called for the personality test.
Yes.
But your contention is.
No, that is my learned friend's allegation. Kindly see the first page, the heading of each column. This is the candidate's allegation.
The allegation.
No, it is his submission.
Yes.
That
But
I was.
what is our note? Our note is the last column, the second last column. That is our remark. Call for first phase personality test.
My learned friend is first phase. What is the first phase?
No.
Mr. Sannal is saying that their contention is that they were not called for the personality test.
Yes.
This is his contention. To that, your note says that he was called in the first phase of the personality.
Yes.
What do you mean by the first phase?
Yes, that I'm coming to because
Before that, you'll also one thing.
No, before that, the court is asking me a question. Let me give one answer at least.
Now let him finish then you answer.
Very well.
My specific case, even in the written notes, that we were called for interview and we appeared. We means here Aditi, Paulomi, Sonchita and
Just a moment. Give us that paragraph, Mr.
Your lordships, kindly page 17 of our corrected written notes.
Abar bole correct.
Kindly see your losses here.
No, that you have shown us. Page 17, this one you are showing.
Yes.
Yes.
Just your losses bottom line. It is clear from the aforesaid chart. If the Aditi Roy gets 1.14 marks in the interview, she will have a berth in the panel or merit list, if not at least in the waiting list.
Your allegation was that I was called for the interview.
I participated in the interview.
But my marks were not given.
Marks were not given. Why page 51? That's page 51. Kindly look at this. Called in first phase of PT. Personality test.
Yes.
First phase of PT, if I understand correctly, those who were initially called for interview and those subsequently by the order of the court, it may be. But I was in the interview list, I was called for interview and I appeared. Then your lordship, second point, rejected letter due to decrease of 10 marks during verification. This was the result of my keeping out of the panel or merit list.
That was Paulumi.
No, all Aditi, Paulumi, all your lordships.
Yes.
All of them. And then third, decrease from 128. I am holding my mark sheet with the marks 128. They say this should be 110 on the basis of their own photocopy of the marks OMRC. They don't have the original also.
These persons did submit representation on the basis of the.
Yes. No, these were not because they were in the interview list. The ones were those who are not
in the interview.
Exactly, they were in the interview list.
All right. Yes, ওরটা কোথায় লিখেছো? এখানে লিখে দিও। Yes, judgment reason.
I have my interview letter also. I have all of them. If you also
No, we are not disputing that. Kindly come back to page 15 of our notes. Kindly come back to page 15. What is first phase? What is second phase? Let me explain. On the last day, Mr. Sannal argued something totally different. He said that first phase was prior to setting aside. That was
No,
his,
I never said.
that was his last.
No, I
will
never said
document.
it. He did not
No.
say that. He's
That is what I understood. That is the note I understand.
Acha, you explain. Tell us.
Kindly see page 14. Kindly see page 14. Towards the middle, there is the second box, interviews personality test. Persons called for interview 15,436. Persons who were called for interview before grievance hearing.
Where you are reading?
My lord, page 14.
Page 14. Yes. Which column?
The middle column.
Yes.
After the heading, after selection process being set aside.
Yes.
Then the second box, interviews personality test. Your lordships have got it.
Which column you are reading? This one?
Yes, yes.
Which right hand side column?
No.
Middle column. Figures.
The entire length I will be reading. Kindly just.
Where you are reading? Persons who are called for interview before grievance hearing.
Yes, yes. If we start from there, then the figure was 15,436. Persons who appeared in the interview, 12,778.
This is interview for grievance hearing.
No. This is interview. Kindly see the left hand side.
Before. Persons who appeared in the interview, 12,000.
This is first phase. This is first phase.
And what is the second phase?
Second phase is the very next column. Candidates called for interview as per the order dated 30/09/2022. 1,585. And then a few more were added and it came to 1,588. The middle column.
All right. Yes.
So this
Thank
is.
you. Yes, doctor.
Very well.
শোনো কিভাবে না ওদের একটু কাগজগুলো অ্যারেঞ্জ করে আমরা করতে পারবো হ্যাঁ ওটা দিয়েছে কে চায় the judgment in a compilation?
I had your losses in the compilation.
No, I was saying these four judgments.
Four judgments.
These are the four judgments. Did you prepare any compilation?
Well, I have not. If your losses request that, I will give it your losses with compilation tomorrow.
Your lordships have got the commission's compilation.
Yes.
And apart from this, my lord, I have distinguished the judgments.
Yes, that you have given. That is the commission judgments you have distinguished. So these are your four judgments. আচ্ছা এটা মিস্টার সান্যাল বলে লিখে
And Mr. Bhattacharya, my lord, only.
আসছি so Mr. Sannal, your junior will be anyway we shall find out. থাকুক আবার নয়
I can give you losses tomorrow. Yeah, all the time. That's compilation. What is that there?
There are three judgments, my lord.
আচ্ছা ঠিক আছে ওইটার উপরে না
92 Indra Sound.
ইন্দ্রসানি don't give ইন্দ্রসান এইটার সাথে এইটা একটু স্টিক করে রেখে দেবে এটা মনে মিস্টার সান্যাল আচ্ছা আর এই ওর তো হলো URC have given. Yes, Mr. Shamim.
Yes, my lord.
Doctor
Mr. Bhattacharya, my lord, only refer Indra Sound. And another thing is that, my lord, kindly record, my lord, the Shubhankar Naik's affidavit, supplementary affidavit, because the School Service Commission not yet answered about Shubhankar Naik and as well as P. My lord, kindly record it, my lord. No, Shubhankar first affidavit. My lord, remember the Shubhankar Naik passed in two TET 2011 as well as 2015. He fill up the forms with 2015 marks, and he got, my lord, higher marks than the last selected candidate in interview process, my lord. And they says, my lord, in response of Shubhankar Naik, they says due to manipulation, my lord, he is not called, but he is also passed the 2011, my lord. In this regard, my lord, I filed.
Mr. Swami, is he in the, he is not in the merit list?
Not in the merit list, not even in the interview list. But whosoever call in the interview, his marks, the Shubhankar Naik marks is more than the last interview candidate, my lord.
So Shubhankar is an added party in
Yes,
the
yes, yes.
senior matter.
Yes, my lord.
So he did not make a representation to the commission.
Yes, my lord.
So what was the result?
They says, my lord, in response of Shubhankar Naik, they says, my lord, that's why I filed the first supplementary affidavit of Shubhankar Naik, my lord, para 4, affirmed on 15 January 2024. In pursuance of court order, my lord, I filed this supplementary affidavit. But if my it's not with my lord now, but may I hand it over, my lord, because this is my. Kindly take the para 4. Para 4, my lord. What was the School Service Commission response? It is quoted, not qualified in TET. That was their quotation regarding Shubhankar Naik. But Shubhankar Naik participated in the both the TET. In TET 11, in
This is your supplementary.
yes. In pursuance of court order, my lord, I filed this supplementary affidavit.
Now, what is the answer of the commission?
My lord, kindly see. Para 4, 5th, 3, 4, 5, 6, 7, 8, 9, 10th line. What was the commission's response? Not qualified in TET. That was the commission's response. But I participated in both the selection process, and I also annexed my both mark sheet in page 14 and 15. Kindly see.
But where is this reflection in page 15? Chart which they have given?
Malad, they says malad at the time.
Come to the chart.
Shubhankar. You got in Shubhankar.
Is the number of person who opted higher person?
Is not. Shubhankar থেকে চারটে দিয়েছেন আপনারা? দিয়েছিল। I just.
That point was dealt with by Justice Bhattacharjee.
No, my lord. Shubhankar, that point of time, my lord, Shubhankar Naik was in the list, merit list, my lord. That is first selection process, my lord. That selection process, my lord, was cancelled, my lord. After that.
So they are 2011 to 2015.
Yes, my lord.
Now, when the new selection was done, from the major pool it was done, interview list was prepared, subject to whatever arguments are there. Now, in this interview list, Shubhankar was there?
No, not at all. Because why they says, my lord, at that point of time in the year 2016, my lord, I fill up the form with TET 2015 marks. Why I fill up the online application?
You got more
higher marks, my lord. When they reassess my TET marks, even the second round of selection process, after Justice Bhattacharjee's order, my lord, they says even after interview, they reassess. That's the 27th March, their affidavit, my lord.
Yes.
So, my lord, after interview, if they suppose
he assessed after
interview.
Were you there in the interview list?
No, not at all. That's my submission, my lord. Even if they reassess after interview, then
why didn't you raise that plea at that time?
Yes, I raised it. That's why.
You were petitioner.
No. At that point of time,
that exclusion was much prior.
No. After
20 was the Justice Bhattacharjee's order.
No, my lord.
20 December was Justice Bhattacharjee's order.
Yes, my lord.
After that, the interview list which you say that you have not been included due to not taking into consideration my 2011 TET, that you ought to have been agitated at that juncture.
At that point of time, there was no such opportunity because of the
Interview list was published. Show us any representation that you objected.
page 49 of their law notes.
Page 49.
Yes, my lord, law notes given by the SSC,
SSC law notes, yes.
page number 49.
Second.
But
সেই রিচেকিংটা তো হয়েছে।
You are not within 1463. Subhankar Nayak.
Shubhankar Nayak, according to them, I was in the first phase. Kindly see the page number 49 for
You were in the first phase. That
yes, first phase of PT.
So
But I was in the first phase. They says, my lord, kindly their contradiction. Kindly see their contradiction.
on that.
My lord, because of that, my lord,
On the first phase.
yes,
So your name did not feature in the merit list.
no, that's why I am before this court. My lord, what?
You were also not excluded from 1463.
No, they says you are in the first phase, but in second round, first phase. Suppose, my lord, out of that 15,000, 14,000, they says it is first phase, and the others remaining 1,500, this is second phase according to them. In first phase, I was there. My lord, what's the contradiction is that, my lord, why I want to canvass it? Because in their affidavit, they says after completion of interview, they reassess or recheck. My contention is that if after interview process, it reassess, then how could you ostate me out?
No, they have rechecked the entirety of it.
Yes, my lord, because after what
No,
phase?
you were there within 12,770.
Ought to be. Now, my lord, my contention is that kindly think this contradiction.
No, these 12,778 are the persons called who applied for grievance redressal.
They at that point.
36, you were there.
Yes.
So your grievance was considered.
No, I am not made any grievance because at that point of time I was considered.
They are within 12,770.
Yes.
Then what happened?
After that, my lord, what they did, my lord, kindly, that's why their response, kindly read their response. He was called in the first phase of PT, but his candidature was later rejected as he was not qualified in TET. Now, my lord, my point is that I qualified in both the TET, in TET 11 and TET 15. Now, my lord, I fill up the form on the online application in the year 2016. If I rejected in 2015, in this later stage, then I might fill up the form with 2011. They did not even give any copy, whether I am defaced category or any other category. Why they says you are not qualified in TET? I not even kindly turn, my lord, my supplementary affidavit. I annex both my mark sheet, my lord, 2011 as well as 2015. Kindly turn page number.
What was your mark in 2011?
2011, my marks, it is shows, my lord, 97.
Present score was 79.
And my lord, this marks obtained in 2011, 52.75 at that point of time, page 14.
Now, what is the supplementary evidence? Did they give any reply?
Not here. That's my contention. They did not give any reply.
Shubhankar
Nayak. And second thing is that Pinky Ghosh, they not yet reply. Pinky Ghosh regarding absentee.
What more reply they will give? Your argument was I have not been sent the interview.
Yes.
Not in any.
But
was not in any.
এখন বলছে 79 how
Now, did you issue interview letter to Pinky?
My lord,
To Pinky Ghosh?
her name was very much in the interview list, but she was absent. She did not.
No. Was he sent any letter for interview?
The intimation for interview in all probability was given through the website. All candidates appeared through the website. Their contention is that the name was not in the interview list.
We are wanting to ascertain. Did you give individual interview letters you have given, or by website publication it was done?
They were to download it from the website.
Individual text messages you have not sent?
No. They were to download it from the website. All candidates did so. All candidates appeared. And when this question was raised, because it was raised today, I did not get the opportunity to check from the records. But the chairman was present in the courtroom and I asked him. He said the name was definitely in the interview list, but she was absent. As from the document which we have annexed to our law notes, it appears.
Which document?
My lord. My lord, page 54. Page 54.
54 of what?
Of our law notes.
Yes, a page.
Only uploaded. Interview list was uploaded.
Yes.
The person was required to download the same.
Download the call letter, the intimation letter. Everybody did it. 12,000 or more candidates did it.
Yes. May I give the answer, my lord? My lord, kindly.
Answers, it will never end.
Yes.
Either be accepted or rejected.
My lord, they says they publish the interview list. The dictum of the rule is that they ought to publish the interview.
Not go into that.
My
We
lord,
are asking, was there any website publication or not?
but my name was not featured in that interview list. That's my allegation, my lord.
Your name in the website publication, your name
Not
was
there.
not there.
No, that's
Where
my.
you stated that.
But in law notes, my lord. That's my contention altogether, my lord. Our law note. Page. Our law note. That's my contention, my lord. I got higher marks than the last selected candidate.
More than 2,000 candidates were absent. That
Which-
document which your lordships are saying at page 54 shows 3 or 4 candidates absent on that page alone.
Para 31, my lord.
Paragraph
31
of your
law notes, my lord. And in response of that law notes, my lord, in their law notes, they says absentee. But they're not.
Paragraph 31.
Yes, my lord. Of my law note. May I hand it over, my lord? My lord, again.
Wait, sir, we are already. This is your law note.
Yes, my lord.
Para 31. You were not included in the interview list.
Yes. Because
That is their statement.
produce the interview. If they produce the interview list, where I am there, because of that, my lord, dictum of the rule is that they ought to publish the interview list. I checked it, the list. There, in pursuance of court order, they publish 3 lists. One is that who within that category, within come in the zone of the cancel consideration, who are rejected even, but my name is not featured in any of the lists. That's my
Now,
contention.
Dr. Patra, about Shubhankar, you have to say, can you throw some light?
It is correct that the candidates had the option of using either of their text answers. That I will not deny. And it appears from the affidavit that he had appeared in both. He relied on 2015 thinking he would get a better TET weightage. But ultimately, since we reduced his marks on the verification, then now he wants to rely on the TET 2011. Now, that I leave to your lordship, because the candidate knowing...
No, in respect of all candidates, you have taken which mark? The 15th mark or 11th?
The marks which the candidates have opted for. They were given the option that either to...
So this Shubhankar opted for...
All did not have 2011. The new candidates did not have 2011. But some candidates had.
So whatever they opted for, you calculated on that day.
Yes, yes.
Now, his contention is Shubhankar appeared in both 11 as well as 15. But he gave his number
of 15, thinking that the marks were better.
No, he got in 15, in
97.
79.
97.
Previous score was 97.
Yes.
So you gave the 97 score, 2011 score.
Yes, yes. Madam, kindly turn page number 14 and 15. Both the mark sheet issued by the SSC, I annex both
page 14
and 15 of supplementary affidavit filed by the Shubhankar Nayak. Page 14.
Yes.
That is 2011 mark sheet issued by the West Bengal Central School Service Commission. I got marks obtained in examination 52.75.
52.7, right?
Yes, yes. And in the second page number 15, my lord, which issued by the again Central School Service Commission in respect of 2015, I got 97 total score out of 150. So that is how higher marks.
Where is 97?
We got it, my lord, total score.
Oh,
Marks obtained, total score.
97.
Yes, my lord. That is higher marks than 2011. 64%. 64% is higher than 52.75%. So, my lord,
52%.
yes. Earlier occasion I got 52.75%.
Why? Here,
Out of 90.
yes. Why you have written
Out of 90 marks. Page 14. The top full marks 90.
Yes, percentage. Out of 52.75.
52.75. So that would be a little more than 50.
That is 2011.
Yes.
Yes, but
This is out of
90. At that point of time, 2011 TET marks was 90.
Where is the total marks given?
At the top. Right at the
Oh, I see. Yes. So out of 90, you got
What?
52.75.
Yes, my lord.
And in the 15 TET, you got 97.
97.
150.
Out of 150.
Yes. That is also,
115 was the total.
Total marks.
that is
That is also written in top of the
now this is converted to the weightage.
Weightage, how you calculate? Percentage.
150 by 50.
97 by 150.
Yes.
And that is 52.75
52
by
by-
90.
Yes, no.
58%.
That is earlier occasion
Where are you
58%.
getting 58? It is 52.7.
No, my lord, that is marks out of 90. My lord. If you